This panel will discuss recent legal developments on benefits, tax, and regulations that involve and impact public pensions. The panelists will discuss timely topics including the Tax Cuts and Jobs Act, federal regulations, judicial decisions, and investment contracts. Please help me welcome Tony Roda, who will moderate this session and introduce his distinguished panel.
Thank you, Tina, and thank you, Hank, and thank you, NCPers, for putting together another terrific conference, and I'm very happy to be here in Austin with all of you. A little bit about my background before I introduce the panelists, but I'm a partner at Williams & Jensen, a DC-only based law firm. I've been there for 27 years, and a large part of that time I've been working on public pension issues, and I've had a great relationship and have represented NCPers on federal issues since 2007. Great relationship, and we've made some tremendous strides, I think. This morning we're going to cover, as Tina said, several important topics. We have two accomplished panelists to help us walk through the issues, and I'll chime in and use my moderator time on some of the federal issues. We can do Q&A at the end, but certainly if I see someone's hand in the middle of one of our statements, I'll be sure to stop and recognize you. Let's start with Peter Mixon. Peter is a partner at Nossaman and works out of their Seattle office. And many of you know Peter from his long-standing tenure as the General Counsel of CalPERS. He is a frequent speaker, panelist, writer on all things public pension. He is a member of Nossaman's public pension team and investment group and concentrates on trust law, investments, benefits, and funding issues. He has a BA degree from the University of California, Berkeley, a JD from the University of the Pacific. And Peter, thank you for being with us this morning. Next, we have Rob Gauss, partner at ICE Miller in their Indianapolis office. And Rob is also a well-known lawyer, advisor in the public pension community, a frequent speaker and panelist, and has provided me over the years with some great counsel. He concentrates on helping state and local governmental employers and pension plans with benefit questions, specifically tax, compliance, and fiduciary responsibilities. He has a BA from DePauw University, a JD from Indiana University, so you can tell that Rob is a Hoosier through and through. And I appreciate his counsel, and let's get started. So we're going to start, as Tina said, we've got a long, big waterfront. So let's start with the benefits section, and I'm going to turn to Peter on that and talk about some of the litigation that has taken place in California, specifically around the California rule. And I'll ask Peter at the outset to explain what the California rule is, and also why people outside of California would care about the California rule.
Thank you, Tony. Listen, it's great to be here. NCPers is a fantastic organization, and their mission is, of course, critical, as everyone in this room knows. So why talk about the California rule at a national convention? Well, California, at least in vested rights litigation, and as Tony alluded to, the California rule, is sort of a leader in this area. At least over a dozen states currently follow some variation of the California rule, and even other states which may follow a variation, maybe not the California rule itself, but a contracts analysis in their evaluation of public employee vested rights, will certainly look to the California decisions in sort of their analysis of their own state law. So the California rule, of course, as probably everyone in this room knows, has been under strain, to put it mildly, both in academia and I think in some cases outside the state. But in California right now, there are a series of cases where the tenets, the longstanding tenets of the California rule, have been challenged. And these cases arise out of pension reform, a pension reform bill that was passed in 2012 called PEPRA. And PEPRA made a large number of changes to both the structure and the benefits of public pensions in California, but mostly, at least on the benefit side, mostly for new hires. And so for those folks who come in, they come in under that structure or those benefits, and so their vested contractual rights aren't really affected because they're creating a new contract. But for the existing employees, there were also a few changes, and for purposes of our discussion here this morning, they relate to, first of all, airtime, the right to purchase airtime, which was a statutory right granted to state employees prior to the passage of PEPRA. And then pensionable compensation. There were changes made in what goes into, beyond your base salary, what goes into pensionable compensation or compensation earnable, there's other terms, for all public employees in California, not just state employees. So the first case I'm going to talk about dealt with airtime. It's called the CAL FIRE case. And the Supreme Court issued its decision in March of this year, basically validating the legislature's decision to repeal or rescind airtime rights for the state employees. During the briefing of that case, there were a lot of folks who came in and said, look, you ought to take a hard look at the California rule, you ought to consider making changes, or on the other side, keep it exactly as it is. But the California Supreme Court declined to go there and expressly said, we're not making any rulings or judgments on the California rule at all. Instead, they held that the airtime purchase right was not a core pension benefit in and of itself, because the employee had to actually sign up and actually make a separate agreement to purchase the airtime. It wasn't affected by the contracts clause, and because it was not made irrevocable, the California legislature had a right, in effect, to revoke that right or revoke that offer without violating the contracts clause or the vested rights doctrine. And they made it crystal clear, we're expressing no opinion on the California rule. But in the queue, next up, is a case called Alameda, the Alameda County Employee Retirement Association case, which deals with the second part of this, the pensionable compensation, where the legislature made a number of changes as to certain types of compensation and whether they're legally allowed to be included in pensionable comp, and restricted those types of compensation, like overtime, callback, and various other types of supplemental pay. And there is litigation currently going on. In fact, there's at least 5 separate cases that challenge various aspects of those laws. They were all consolidated at the California Supreme Court level, and the lead case is called Alameda. That has been fully briefed, and the parties are just waiting for oral argument to be set. No indication when that's going to occur, although in my opinion, is that they will set oral argument before the end of the year, in which case, once that's been concluded, the Supreme Court will have 60 days to issue their opinion, probably by early next year. That case will deal with the California rule, and we will see.
Very important, Peter. Thank you. Rob, since we're in Texas, there's some Texas litigation that bears on this as well.
Yeah, and it was ironic that the same week the California Supreme Court decided the CAL FIRE case, the Texas Supreme Court decided a case by the name of Eddington versus Dallas Police and Fire. And this had to do with a change in the drop interest crediting rate. The Dallas Police and Fire Board had decreased a stated interest rate, and suit was filed. The most interesting part about it was that there is a Depression-era case from the 1930s by the name of Trammell that had existed for 80 years. and Trammell said that benefits, in essence, are a gratuity. And so changes, reductions could be made. And then subsequent to that case, Texas adopted a constitutional provision that protected benefits from a public plan and prevented their impairment. So the question was whether or not the court would go back and look at the Trammell decision, or how it would interpret that more recent constitutional provision. And in essence, the court said that that reduction in the interest rate, the drop interest credit rate, did not impair a vested right because it was prospective in application only.
Very important case. I also asked Rob to give us kind of a couple minutes overview of what he sees as trends in the state legislatures with regard to, well, I'll use the word, attacks on benefits.
Yeah, I think most of you have seen the road show that goes out from one legislature to another, sponsored by various interest groups, the Reason Foundation being one, some local folks here in Texas who have a special interest in the area. And the idea is the same. We want to change your defined benefit to a defined contribution plan. And that happened in Oklahoma back in 2015, where they closed the DB plan and went to DC only. But I think right now the move is more towards either hybrid or cash balance. And just this week, the Speaker of the House in New Jersey has floated the idea of going to a hybrid plan in New Jersey. So we need to wait and see. The one thing I will mention is that as they go on the road show, and I experienced this with South Carolina, they were testifying before a joint panel and encouraging this move to a hybrid plan and saying, well, look, you can allow an opportunity to change or an election to all your current employees to go from their DB plan to the new hybrid plan or DC plan. And that's a big sales pitch that they make, is you're going to give this election to new employees. The incentive for taking a reduced benefit is you're going to pay less. And what they don't talk about is that that's an impermissible election that violates the Internal Revenue Code. And I was watching the testimony in South Carolina, and they said, oh, yes, you can do this. You can have this election. They did it in Kansas, and they give the statute site. What they fail to say is that that statute specifically says you can't have an election unless the IRS gives a favorable private letter ruling, and that election has never gone into effect. So you have to be very careful anytime you hear people coming to the State House encouraging that you're going to give current members an election to move to this new either cash balance or hybrid plan.
So that's the pickup rule.
Correct.
For shorthand. And I would anticipate, as we've seen in 3 of the last 4 Congresses, this would be the 4 of the 5th Congress, that we're going to see legislation introduced to provide more flexibility on the pickup. I've not seen it yet, but I know that it's in the pipeline. And such a flexibility measure did pass the House, Republican-controlled House, in the previous Congress. I don't expect it to get far in a Democratic-controlled House, but the issue still is out there very much, and people are continuing to ask for flexibility. I'll mention quickly 2 other federal issues. We've talked over the years about the Social Security penalties known as WEP and GPO, windfall elimination provision and the government pension offset. It's not a benefit issue, but a benefit derived from non-FICA earnings is what triggers those penalties. So there has been a tremendous amount of talk at the House Ways and Means Committee on Social Security reform. have been 3 hearings already in this new Congress. And in each hearing, the issue of WEP and GPO has come up. And a number of members on both sides of the aisle have spoken about this issue. So I don't anticipate major Social Security legislation in this Congress, but I think when ultimately Congress gets down to doing it, WEP and GPO will be addressed in some fashion and favorable to what we're looking for. The other issue I'll mention before we switch over to tax, the tax front, is Medicare. And again, it's not a benefit issue, but it is, in as much as many states and municipalities that have for years provided retiree health care are eliminating or cutting back significantly on those programs. We've seen that kind of in a patchwork across the country, but it's certainly a trend that's out there. Congress right now has a spectrum of legislation on Medicare. You all know about Medicare for All. There's an alternative to Medicare for All, which is Medicare, early age Medicare buy-in at age 50 for all. That's getting a little more support in the centrist part of the Democratic Party. No Republicans yet. And then there's going to be a third. And I would suspect this legislation will be introduced in June. Sherrod Brown in Ohio, Tom Malinowski in the House, and Harley Roda in the House are going to introduce legislation which would be an early buy-in for retired first responders only. And they have not settled on whether it's age 50 or age 55. But the argument is these folks are always going to have a gap between retirement and Medicare eligibility age of 65. This is a deserving group. This is a reasonable ask. We'll see. And we'll see what kind of support this gets on the Republican side of the aisle. It'll go in with just Democrats, but I suspect that this is the type, and maybe the only Medicare expansion legislation that will get some serious attention from the Republicans. So look for that happening in the next month. We're going to switch gears to the tax front, and there is major legislation moving through on tax. The House this week is going to vote on what they call the Secure Act, and the Senate has an alternative proposal called RISA, and Rob's going to talk about these proposals a little bit.
So the Secure Act is more directed towards the private sector, 401k accessibility for people with small employers, IRA, changes to the IRA rules. But there are a couple of pieces that are very interesting to us and to you. One is a proposal to increase the age for required minimum distributions from age 70 and a half to age 72. That would be effective at the end of this year. So just by way of background, you have to start commencing your benefit by April 1 of the year after you either turn age 70 and a half or you retire. And so this would extend that age to age 72. It also modifies the required minimum distribution rules for certain defined contribution plans to require a payout of the entire interest after death, to require that payment within 10 years if the beneficiary is a non-spousal beneficiary or a non-qualified beneficiary. And then it gives a full definition about who these non-qualified beneficiaries are. But the main part to watch for is is that going to get any traction? And it would require a payout of the entire interest within 10 years from certain DC plans, 401A DC, for instance.
Thank you, Rob. I'm going to switch over to Peter now. We're going to come back to tax for a couple rifle shot issues at the end, but I want to get Peter back in the conversation and talk about fiduciary, because there is some interesting activity at the Department of Labor, and then on proxy advisors, there's some activity at the SEC.
Thanks. Yes, Tony. So first of all, I'll talk about the intersection of environmental, social, and governance investing and fiduciary duties. The Department of Labor in recent years, in fact in the last two administrations, has taken an interest in this sector of ERISA plan governance. Now, of course, we all represent governmental plans in this group, and governmental plans are exempt from ERISA. But nevertheless, the fiduciary standards that are embedded in ERISA are based on the common law of trusts. And most states in this country, when it comes to the fiduciary duties of their public pension plan trustees, that law at least starts with the common law of trust. There are, obviously state by state, there are twists on that, but at least the base is the common law of trust. So there is some correlation here, and I think that most lawyers that advise on fiduciary duties and investing at least look to ERISA cases and by extension guidance by the Department of Labor as a source of guidance when they advise their trustees. So what's going on here? So there are two, just by way of background, there are two analytical structures, I guess, or methods of analysis of ESG investing, and that is when a trustee or when a fiduciary takes into account these factors when they make an investment decision, how do their fiduciary duties impact that decision? And so the first has been longstanding, and really I'll just mention it and then move on, and that is the collateral benefits rule. Whereas everything else being equal in terms of the investment characteristics of a particular decision, the fiduciary can look to ESG factors as a collateral benefit, provided there's no injury to the members in terms of the risk profile, the performance, the return, the liquidity aspects of that investment. The DOL really hasn't strayed from that analysis in the last, say, 20 years. But they've looked at a new and sort of emerging analytical structure, and that is, and I think probably a more important one in the long run, is these factors being embedded in the decision-making process itself. In other words, they're not looked at as a collateral benefit, but they are factors to evaluate the performance of the investment, the risk characteristics, the liquidity, sort of its importance in advancing the overall investment goals of the plan. And from that standpoint, DOL has issued a series of these things called field assistance bulletins. They're not law by any stretch. Instead, they are guidance that the department issues to its regional offices on how to answer questions when these issues come up. And so during the Obama administration, they issued at least one field assistance bulletin, which I think overall was very favorable to taking into account the idea of taking into account ESG factors in the decision-making process, provided that those factors were, and I think the words were, directly related to the return, the performance, and the liquidity of the investment. More recently, the Trump administration DOL has come out with yet another field assistance bulletin. They came out with it last year. And while they didn't really, I don't think, undercut that concept of direct relationship, instead they sort of issued, it was a little bit more cautionary. Like, I think their language was something like, trustees must not too readily take into account ESG factors in their decision-making process. And they also, in this field assistance bulletin, also talked about shareholder engagement, whether that's voting proxies or directly engaging with publicly traded companies, on their investment strategy or their practices or whatever. And again, they accepted the premise that it is consistent, in fact, in some instances, I think, required to vote proxies and engage. But they, again, it was a little more of a cautionary role. They suggested that in certain types of cases, the plan might wish to do a cost-benefit analysis in terms of the amount of money that's being expended on these activities versus the benefit that will accrue to the plan. Long story short is I don't think that certainly there's been no change in the law on fiduciary duties from the standpoint of the Department of Labor. I think this is more the pendulum sort of moving back and forth to a certain extent, again, at the middle regulatory level, and I don't think it's really going to have an impact on the current ESG programs and public pension plans.
Thank you, Peter. That's very helpful. Do you also want to talk a little bit about proxy advisors?
Sure. We'll talk a little bit about what's going on with the SEC and proxy advisors. So I think probably as most of you know, first of all, proxy advisors are those firms who provide advice to all institutional investors, as well, including public pension plans, on voting proxies, and other, I think, corporate governance activities of institutional investors. And they are currently not regulated by any federal regulatory agency, even though they do provide advice in a fiduciary context. And so for many years, there has been a push, primarily by the corporate community, to have the SEC get involved in some sort of regulatory activity with these agencies. And so the new Chairman Slayton, in December of last year, issued a call to his staff to put together proposals, potential proposals for rulemaking on regulation of these proxy advisory firms. And to follow up, there was a letter that I saw that was sent to the chair in February of this year. I think it was signed by like over 1,000 publicly traded companies saying, yay, 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 go forward. This is a great idea and we want to support you and that sort of thing. So I think there's three areas that the SEC could get involved in terms of regulation. And the first is conflicts of interest. There's been a lot of discussion about the position that the proxy advisory firms are in terms of providing both advisory services on how to vote proxies, and then at the same time providing consulting services to companies themselves about how to make changes that are favorable in terms of the advice that they're giving the institutional investors. And so certainly the corporate community is concerned about that potential conflict of interest, and they want to see it regulated. The second area that they are interested in is transparency. How do proxy advisory services come up with their policies? What are those policies? How do they differ across different types of institutional investors? What is the input? Even the corporate community wants input into how those policies are created or those standards are created. They even suggested in their letter that there be a, quote, notice and comment period, which seems to suggest that they would like the SEC to require the proxy advisory services to go through some sort of rulemaking or akin to a rulemaking process. So that's one other area I think that they're definitely going to be interested in. And then another complaint the corporate community has is the accuracy of the advice that's being given to their clientele. And they always have long complained that the advice is based on faulty premises or that the advice is just flat out inaccurate. And so their complaint is that they want a process where for a particular proxy vote, if the company itself disagrees with either the factual basis that the advice is based on or just disagrees with the advice, I guess, that they want a process where they can engage with ISS or Glass Lewis or the proxy advisory services. And they'd like the SEC to weigh in on what that would look like and what the rules would be. So that's a lot to consider. I don't know if the SEC is even going to be interested in going as far as the corporate community wants them to, But I do think with the chairman's speech and his testimony, I do think that we should be prepared for some sort of proposal that at least addresses the conflicts of interest issue. Because at the end of the day, they are akin to fiduciaries. They're giving advice, investment advice, to trustees who are exercising those rights as a fiduciary. So I think that we can expect something probably by the fall that comes out of staff, and I'm sure this organization and others will be very interested to see what that looks like.
And to comment on it.
Absolutely.
Thank you, Peter. Rob, there's been let's stay on this investments and fiduciary track. There's been some litigation in Kentucky that I think bears some mention.
So, a year and a half ago or so, several members of the Kentucky Employees Retirement System filed a derivative lawsuit. That means individually they filed a lawsuit on behalf of the system, and most of the lawsuit is against hedge fund advisors related to breaches of fiduciary duty, excess costs related to investment, poor performance, et cetera. So it's the first case of its kind at the state level where individual members of the system are trying to bring a breach of fiduciary duty claim, not against the board, but against outside advisors. Also wrapped up in the case are the longtime actuarial firm for the retirement system and law firm. And the claim against the actuarial firm was related to breaches related to assumptions that were used. The claim against the law firm was breaches related to investments that were made. And it's interesting because the lower court, the trial court, had allowed the case to proceed, and just a month ago, the Court of Appeals in Kentucky said, as a matter of constitutional standing, these individuals didn't have the right to bring a claim on behalf of the system. Only the board could bring the claim, and so it is going to the Kentucky Supreme Court. The really interesting part about the case is the claims against the hedge fund managers related to their breaches. Several of the hedge funds then fairly recently went to Delaware and filed their own lawsuits and said, hey, wait a minute, in all these investment documents, you have claimed to be a knowledgeable investor who knows what you're doing, and so if we're found liable for breaches in Kentucky, then you're going to have to indemnify us in our Delaware case, because in the disclosures you had acknowledged that you knew what you were doing in these investments. When the case was first filed, one of the local stations interviewed one of the plan participants who is named, and the plan participant simply said, hey, look, we're extremely underfunded, and if we can get money from anywhere, we're going to try. So at a 14% funding level, this was an effort to try and find some additional revenue for the system, and we'll have to wait and see what the Supreme Court does with it.
Absolutely. And Peter, you had some comments on this?
Yeah, there have been a couple of cases in California, actually one case that's been up and down, up and down, up and down in terms of breach of fiduciary duty. It was not a derivative action, but it was an action brought by the actual members of the plan. And it was not over investment decisions, let me just say that. It was over funding decisions and some of the actuarial methodology that was chosen by the board. But I do think that given the sort of the pressures, the financial pressures and the funding pressures, I think that fiduciary litigation is going to become I'm not going to say it's going to become common, but it's going to become more common as states like Kentucky and in Illinois, where the funding issues are severe, and in California, which I think most plans are not as badly underfunded, but they certainly are not close to 100% funded. I think we're going to start seeing more creative ideas in this context. Just a note, on the ERISA side, on the non-governmental plan side, fiduciary litigation is common. There is a whole industry built around fiduciary litigation against trustees and against advisors in the ERISA context. And really, I think the public pension community has not seen very much of that, certainly while I've been active here, but I think we're going to see more and more of it.
Yeah, I think you're right. And you wanted to comment, Rob, on the 403B litigation in the universities.
Yeah, so that's a good segue. Peter's absolutely right. The same people who had laid the groundwork of breach of fiduciary claims in the 401k context repackaged themselves and brought lawsuits against a number of very well-known private universities around the country. Small schools, Georgetown, UVA, Vanderbilt, Duke, Yale, household name kind of schools. You have to understand that 403Bs are a different animal than most of us are used to. There are a lot of overlaying record keepers, multiple record keepers, lots of investment options available. And so the claims are kind of unique to the 403B context. For instance, one of the claims is that there are so many options available that the member has paralysis in the ability to make a decision as to which fund to invest in. And then, of course, by virtue of all of those investment offerings, you're paying excess fees. TIA-CREF has a number of its own fees that are in these plans, and there are claims related to the performance of those funds, the fees charged. The important part about these cases from our perspective is of the 18, 4 have settled in about a year and a half, and not for chump change. Duke agreed to pay $10.6 million, University of Chicago $6.5 million, Vanderbilt $14.5 million, Brown University $3.5 million. Of the 18 cases, 3 were dismissed at the trial court and have gone to the courts of appeals. One of those cases, the University of Pennsylvania case, recently is now back alive because it was dismissed at the trial court and the Court of Appeals brought it back. And so it's going to continue. And then the case that's really interesting is NYU, which was tried to a judge. The judge ruled in favor of NYU. About 2 months after that trial, the judge retired from the bench, went back to the private law firm that she had come from, which, by the way, was the same private law firm that the chair of the Board of Trustees worked at. So there were filings to have the trial set aside because, of course, she couldn't have been unbiased. A new judge was appointed. That judge has died. So the case is on its 3rd judge.
Wow.
And the moral of these stories, the reason that we're following them is because they become very expensive, very fast. They last for a long time. And for anyone who has plans that are designed around individual investor decision-making, there are going to be learning lessons that come out of these cases.
Yeah.
Peter?
Yeah, I think that, like I said, I think on the ERISA side, the breach of fiduciary duty litigation is commonplace. And I think perhaps in part because those fees they're directly paid by the membership in a defined contribution context. But there is also a healthy defined benefit side to this on the ERISA side. So I do think that again, I mean, this is not a governance, board governance session or anything like that, but I think being very prudent in terms of process in making these decisions is just all the more important these days because of these risks, and making sure that you have appropriate experts, that they're providing reasonable advice that's well supported, and all those things that I think other sessions are going to cover, I think becomes of paramount importance, because that's what the courts will look at in terms of judging whether the board or other fiduciaries have met their duties. And in this one case I mentioned, it revolved around the decision, it very much revolved around what was said and done during the board meetings and what the advice was being given and the basis of that advice. So just to reinforce process.
Increasingly important, absolutely. I promised we'd get back to tax, and we have time to get back to tax. So as Rob was talking about the Secure Act and the required minimum distributions from 70.5 to 72, so that's in the House bill that's going to be considered this week to set the stage again. Meanwhile, in the Senate is RISA. And Rob, take
Sure.
it from here.
Yeah, thank you. So RISA stands for the Retirement Security and Savings Act of 2019. When I mentioned the Secure Act, I said it was more designed around private plans. RISA is a much broader retirement-focused bill. It has over 50 retirement plan provisions in it, and there's a little bit of something for everyone. There are parts that are specific to IRAs and 401ks, and there are parts that will affect us. One of the 401k provisions I think that's interesting to watch is for people who are making student loan payments and so not contributing to a 401k because of student loans. This will allow the employer to make a matching contribution to the 401k in relation to the amount that someone was paying to their student loan. You can very easily, right now it's set up for 401ks, you could very easily see that coming over to the 457 side. So, Secure Act takes the required beginning date from age 70.5 to age 72. RISA phases it in from age 70.5 to age 75. So it goes from 70.5 to age 72 by the year 2023 and age 75 by the year 2030. It also eliminates the required minimum distribution requirements for anyone who has less than $100,000 in aggregate savings. So if you come to your employer and say, look, all of my retirement accounts amount to less than $100,000, there's no required minimum distribution for that individual. And it allows the plan to rely on individual certification as to whether or not they meet that less than $100,000 aggregate. It reduces the excise tax for failure to take required minimum distributions. Right now that excise tax is 50%. It takes it down to 25% and the possibility of even being 10% if there's a self-correction. For those of us a little bit older than me in the room, it increases the catch-up amount from $6,000 to $10,000 if you're over age 60. So right now, if you're over age 50, in a 401k, in a 457, you get an additional $6,000 that you can contribute because of age. This brings another layer of additional contribution on if you're age 60 or above. It creates an exception to the RMD rules for Roth accounts or Roth parts of a plan. It allows non-spousal beneficiaries to roll an interest to another plan. Right now, your non-spouse beneficiaries, the only option they have is to an inherited IRA. This would allow them to to do a rollover to any other qualified plan, just as a spousal beneficiary could. And Tony, you're going to have to help me with this one. It creates a special exception to the early distribution rules under Code Section 72T for just firefighters. Right now, under 72T10, there's the special exception for qualified public safety employees in a governmental plan. This strikes governmental and public safety and includes firefighters. And you want to talk about the genesis
Yes,
of
just
that?
briefly, I talked with the IAF when I saw this provision, and it's really, the construct of 72T10 is public sector. Initially, it was just state and local, and then federal law enforcement and firefighters came in probably about 3 years ago. And this would expand it on the firefighter side to private sector firefighters. Now, I don't know if I could add anything to where those folks work. We were speculating about they may be airports, they may be even the smoke jumpers. Don't hold me to that because I'm not sure who the private sector firefighters are. I don't think they're a tremendous number. So this provision is in there, at the request of the firefighters, and I don't believe it's controversial in any way. I will reclaim my time for just two quick things, and we're going to try to leave some time for Q&A, but on the regulatory side, we've been watching for years the development of rules around specifying normal retirement age, and I'm not going to go into this long travail that goes back to 2007. But we thought we were close a couple years ago with proposed rules that our community was very happy with. And then the Trump administration came in, and any administration change like that is just going to put everything that was proposed to the back burner. So we're still on the back burner. We are hopeful that these final rules on normal retirement age will be done, but there's no timetable on that. And likewise, back to 2011, I believe, there was an advance notice of proposed rulemaking on the definition of governmental plan, kind of a fundamental issue for our community. An advance notice, not even a proposed rule. We've seen nothing on that. There were 2,500 comments back then, a lot of them related to charter schools, which are kind of, under the law, a hybrid entity. And Treasury and IRS followed up on the charter schools. Peter, I think, might want to talk about
the grandfathering issue.
Exactly, exactly right. And those, it was a Treasury notice that was going to be incorporated into the proposed rule. So we have that Treasury notice on charter schools, but we don't have anything proposed on definition of governmental plan. And again, no timetable on that. I was hoping to get to infrastructure. I'm just going to mention it quickly, and then we can turn it over to Q&A. But today, Tuesday, President Trump is meeting with congressional leaders to talk about funding for infrastructure. At long last, we've gotten to this important meeting. Now, I don't know that this meeting is going to yield an agreement on funding for, it's a $2 trillion infrastructure program. Over the years, and Hank has been in these meetings, and I know Peter and Rob, they've had contact on this issue as well. There have been proposals, there have been thoughts to try to pull the public pension community into infrastructure funding. Some view you all as a ready pool of cash, as if your cash isn't doing anything else, to come and invest in infrastructure. And there's been a wrinkle on this recently with the notion of actually plans owning assets. And Peter and I and Rob talked about this last night, but I'll turn it over to Peter at this point.
So I think that there's an interest by some public plans in obtaining the investment returns that infrastructure investments provide, because for a lot of reasons, they're protect against inflation, they're real assets, they also, they're long-term investment horizons, at least they should be. which matches better with the liability structure of pension plans, and on and on. And so, and at the same time, I think obviously plan sponsors, particularly for those plans that are severely underfunded, are looking for ways to buttress the funded status of their plans without tripling their employer contributions. And so one concept that's certainly been discussed is making what are called in-kind contributions from the plan sponsor, assets that are owned by the plan sponsor, and transferring ownership or ownership rights, let's put it that way, to the pension plan as in lieu of an annual contribution or in supplement to an annual contribution. That raises large fiduciary issues because of the relationship between the plan sponsor and the plan trustee. There is potentially a conflict of interest there. On the private side, and for ERISA plans, those types of transactions are not allowed unless the Department of Labor specifically approves them. So there is a whole process that the Department of Labor has set up to approve these kinds of in-kind contributions. And, you know, without going into it, essentially they have to be fiduciarily sound. In other words, they have to be for the benefit of the pension plan, not for the benefit of the sponsor. And there's a whole process that's set up which involves special fiduciaries taking a look at it and approving it, independent fiduciaries who don't have an interest in the transaction, and so on and so forth. So I think that there is an interest. There was such a transfer in New Jersey with the lottery, that the state lottery was transferred to the pension plan. That has not exactly a traditional infrastructure asset, but has certain characteristics of infrastructure.
Right.
So I'll just leave it at that. I do think it's an area that there's a lot of work to be done, but I do think that there are folks that are definitely interested in it because of the attractiveness of infrastructure investing.
Thank you, Peter, and thank you, Rob.
Thank you.
I failed to give enough time for Q&A, but I hope we provided you with some interesting thoughts for the morning.
Thank you.